an enterprise would be penalized would have to pay 10% of the penalty imposed by the Competition Commission to appeal for the decision under the DCA. While Competition Act provides that it will have to pay 25% of the penalty. So here there are double penalty because there is no section in both of the acts neither by way of an amendment in the Competition Act 2002 nor in the Digital Competition Act, wherein it is mentioned that how will the Commission deal with such cases, or will it be barred from taking such cases or not. Here, the digital enterprise will face a double inquiry on the same facts, which can be confused because there is a legislative gap between both the statutes, where the violation of SSD obligations can be easily confused as abuse of dominance.
It will be a double inquiry. It can be a one inquiry regarding breach of provisions of both the acts.
Your Lordship, but they deal with different things. DCA deals with the violation of SSD obligations, and there, once the entity violates the obligations, it will be penalized under Section 28 of the statute. But Your Lordship, when we talk about Competition Act 2002, there is no provision in the Act that says that if a digital enterprise is already being regulated under the DCA, the Commission will not accept cases for abuse of dominance. And this is why, Your Lordship, there is a legislative gap between both the statutes where there is no coordination mechanism imposed.
Counsel, are there two different set of obligations according to you under the DCA and under Competition Act?
Your Lordship, yes, because the Competition Act is an ex post law where the Competition Commission intervenes only when it has to inquire into the abuse of dominance of that enterprise in the relevant market. But when we talk about DCA, it intervenes as soon as the enterprise attains dominance.
And we all agree with it. But if there are two different obligations, then why can't an authority have to proceed on those two different obligations? And if they find a contravention, impose reasonable penalty. Commission has a discretion, so it might impose some amount of penalty under this act and some in the other act, or combine both of the inquiries together and then impose a penalty.
Your Lordship, that is to address that. This is because, of course, both of these acts deal with different things. That is not disputed. But the reason why it will give rise to double penalty is because the cause of action for the penalties can be easily mistaken for each other, because there is no provision in the act that basically fills the legislative gap in the sense that violation of SSD obligations and abuse of dominance will be dealt differently. They can be easily confused.
So Technotenna does not trust the Competition Commission of India to be able to identify what is a contravention of DCA and what is a contravention of Competition Act. They'll be confused.
Your Lordship, we are not disputing the competence of the authorities of the country, but we are just saying that whenever anything comes before the courts of law of this country, they can easily decide on that. But here we are concerned about the legislative propriety. A law cannot be made with a perspective that if tomorrow there will be cases, the courts of law will decide on that. The law has to fill the void in the most perfect way, keeping a multi-directional view that there is no scope left for any jurisdictional conundrum in such matters. And that is what we are.
Supposing the legislature may not have enacted a new law, it may have carried out amendment in the Competition Act, introducing a new chapter with covering all these, then what would you have said in that scenario?
Your Lordship, we cannot.
That could have been done, that is within the legislative competence.
Your Lordship, we are not disputing the legislative competence, and we cannot basically suggest what the legislature should have done, because then it will undermine the separation of powers that is completely within the domain of the legislature. Here we agree.
You have been arguing that the provisions will go contrary to the Competition Act, and there is a chance of, you can say, double jeopardy penalty being imposed under. But supposing under one statute for different violations, there are separate penalties provided. And this could have been done by amendment in the Competition Act also. If you would have gone to the aims and objects, initially a commission was constituted and it gave its opinion that why this legislation should be brought in and not why amendment should be carried out in the Competition Act.
Your Lordship, to answer that, firstly, again, I would reiterate that we cannot advise the legislature on how it should go about making the laws. It could have amended, it could have made a different law, that is not we are disputing. But we are disputing it, what we are disputing is that when it has made two laws which are regulating the same digital markets, the arena of digital markets, there should have been a coordination mechanism between both the statutes.
That perhaps is provided under, just see this section 45. The provisions of this act shall be in addition to and not in derogation of any other provision for the time being imposed. So this answers your submission that These provisions are in addition to the existing provisions.
Your Lordship, but that would be considered by the courts of law of this country when they would decide on the case. But the inquiries can still be initiated because anybody can file a case under the Competition Act 2002, and the Commission is not barred to take such cases because the violation of SSD obligations and abuse of dominance can be mistaken for each other.
Thank you.
Ma'am, illegality, Your Lordship, illegality is that there is no coordination maintained between the two legislations in terms of regulating the digital markets to ameliorate their concerns. And if I may take a minute to just justify the overlaps with the Digital Personal Data Protection Act, if the bench allows.
Let the next participant start.
Okay,
Yes.
it was an order to argue before the bench.
Not